9:70 AM पे वेलकम लिसनर्स, मैं हूं आपके साथ में ईरा एंड वेलकम टू शाह पिराली लॉ शो. Yes, it is time once again when we are joined by Shah Pirali. He is the founder, president and managing attorney of the Shah Pirali Law Group, which is right here in Newark, and he is a member of the American Immigration Lawyers Association as well as the State Bar of California. He is a passionate advocate of human rights, civil rights, social action and social services, and he has a strong interest in and knowledge of the political legal system of the US. He formed his law group to work on the courses he feels most ardently about. The law group focuses on immigration law with an emphasis on employment-based immigration, and he helps his clients all over the US. Listeners, his offices are in Newark, San Francisco, and Washington, D.C. If you'd like to get in touch with him, you can do so by logging on to his website, piralilaw.com. That's PEERALLYLAW.com. Or you can also call on 510-742-5887. That's 510-742-5887. Hello, Shah. Good morning. Welcome to the show.
Good morning, Ira. Good morning to all the listeners. Thank you for the nice introduction. And as usual, you're very sweet to be here with us. Thank you so much for welcoming me.
So, Shah, I know that we'll have Sharif joining us in about 10 or 20 minutes from now. Meanwhile, till then, what is it that you would like to talk about?
Of course, first of all, anything I'm going to tell you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. So, ladies and gentlemen, today is August 26, 2020. I think the next show will be next month, so it's probably the last show of the month. I'm not sure. Yeah, it looks like. But of course, we'll be back next month, next week also. And today, as I was telling you, I have some sad news from my island, Mauritius, where they had the oil spill. 18 dolphins died, and of course, this is heartbreaking. Already it was heartbreaking to see the fisherman village gone and things like that, and now you have all those dolphins dying, and a lot of people are believing this is the beginning, and it's really getting frustrating, especially a lot of things happening on the island, and the people are frustrated with the government because they don't feel like they have done enough, and they don't feel like they're telling the truth, etc. So again, we are facing the same problems like we're facing in America here, and I just wanted to do a special shout out to all my friends all around the world, Mauritians like me, the diaspora, who are really working hard to actually have a protest on those issues. So support them, and I wanted to tell people to check on Mauritius what's happening there. This is really a sad story, and it's piling up, unfortunately, and anybody who wants to support, especially the ocean, we have the island had one of the only reserve of marine reserve in the world, not in the world, in Africa, and now it might be gone because of this oil spill. So anybody who can help and support, please feel free, and hopefully I'll try to put more information on that on my Facebook page. So please do that. And special thanks to all my friends. I have my friends Dadas and all those people who are really fighting hard for that. So I wanted to do a shout out for them today. And again, as you know, it's really heartbreaking to see those dolphins dying just like that. It's really sad. So today, of course, we're going to talk more about news in America, because a lot of things happening there, and which are unfortunately related to the world. And we're going to talk, of course, about immigration, and people will be free to call. Maybe you can give the phone number, and so people can call before Sharif joins in. They will be able to call.
Absolutely. So, listeners, if you have any questions about immigration, please call us on 510-657-1170. That's the studio number. The lines are open. Any immigration question, any employment-based immigration or anything at all, if you have any question or doubts, definitely call Shah and speak to him right away on 510 510-657-1170. That's 510-657-1170. That's the studio number where you can call us right away. We have Shapir Ali on air with us till 11 a.m. And if you'd like to speak to him after the show, if you'd like to make an appointment with him or have a virtual consultation to discuss something in private, the number to call the office is 510-742-5887. 510-742-5887. कोई भी सवाल आपको पूछना है अभी के लिए अगर तो स्टूडियो की लाइन्स खुली हैं, आप कॉल कर सकते हैं 510-657-1170 पर. अभी के टाइम पे when there is so much uncertainty, काफी लोग कंफ्यूज्ड हैं, काफी लोग परेशान हैं जॉब्स को लेके, इमिग्रेशन को लेके. सो कोई भी सवाल है आपके पास में कि हाउ डज इट वर्क और व्हाट ऑप्शंस डू यू हैव, आप अभी बात कर सकते हैं शापिर अली से 510-657-1170 पर. यस शाह, लेट्स गेट स्टार्टेड.
Yes, for now, one of the things that a lot of people are confused is about the H4 EAD. Number one, they have kind of relaxed the time. If you apply for an extension, you are able to continue working once you get the 797 approval. A lot of people think that just the 797A, which is the application, allows people to continue working, but actually, from what we are reading, and I might be wrong because I'm getting a little bit confused myself with the way it is written, but with the 797 approval notice, since the cards are taking time to be printed, the contractors are not printing it, they are going ahead and allowing people to work just on that receipt. So now the question is which receipt that I need to do a little bit more research on that to give you an answer. But from Sharif is going to be here, we were discussing about that. He understood that it is after the approval, and I understood it was at the time when you file for the extension itself. So we need to kind of look into that soon, but at least it's something good because a lot of people are just hanging out there. They lost their job, and plus they're not able to work, even they cannot find another job because their EADs are getting delayed. And also a lot of people also are confused on the fact that when you file for the H4, you should also file for the EAD. Okay, don't let anybody tell you otherwise, because the way it works, when you file the H4, it's either you file the H4 or the H4 and plus the EAD, or just the EAD. So it's not either. It's like three ways to file it. So H4 is only if you don't have the potential for the EAD because your spouse doesn't have an I-140 approval, has not gotten an extension of 6 years, beyond 6 years, then you file only for the H4. But if you have an extension and your EAD also is expiring soon, file both together. It's very clear if you look at the language when the H4 EAD was introduced itself, the USCIS recommended people to file that because their department seems to have a H4 EAD or just the EAD. So never wait, because then you lose that time that the case would have been processed. Instead of taking 1 month after the H4 is approved, it will take another 2-3 months. But at least for those who have gotten the H4 approved, go ahead and file for your EADs. It's very, very important that people know about that. Again, for those who want to call, they don't have to stick to what's happening, what we're talking about here, just H4 EAD. If you have any questions regarding immigration, whether it's H1, O1 visa, EB1, you name it, feel free to call 510. I forgot the number now. 510.
The studio number?
Yes.
510-657-1170. That's 510-657-1170. That's a very good point that you made over there, Shah, about the H4 visa extensions or approvals, and also EAD, because there was also some confusion in between that the extension or the approval is taking time because a lot of people are also filing the EAD at the same time. But you said that it is totally doable and one should do that rather. It is recommended?
Yes, highly recommended, because then the timing is lessened by you doing that. Because look at it this way: if you file the H4, minimum 6 months of waiting, and if you do the EAD after the H4 is approved, it's another 2-3 months. which makes it almost 9 months.
9
but
months.
if you file it together, there's only usually like 1 month after, sometimes 2-3 weeks later, you get your EAD, because the EAD doesn't have a fingerprint. It's the H4 that takes time. So if you're eligible to file for the EAD, of course, if your EAD expires, usually it expires together, so there's no problem, but you need to make sure that you file it together if you're eligible for it. And that's the best way to do it, and that's how we have been doing it for years now, going on 5 years. So don't let it go, lose that chance, because this is a very good chance. So just letting people know when it comes to H4 EAD what's going on. So another thing yeah, go ahead. You had a question?
I was just going to ask you if you said that H4 does not need fingerprint. H4 needs fingerprinting now, but not the EAD. But on the website somewhere it also says that biometrics or the fingerprinting is also required for the EAD application. So if somebody has got the approval, do they also need to go for their fingerprinting again for the EAD?
Well, that's a $1 million question sometimes, because honestly, we know that the EAD itself doesn't require fingerprint unless you're filing the EAD separately. But then if they just did your fingerprint, usually within 15 months they won't do it again. So it's a case-by-case basis, but most of the time for those who are filing, just like for example, many people, what they will do, they will travel outside, come back, get their H4, because that goes faster, and then after that they will go ahead file the EAD. In these kind of cases, many times you will have a fingerprint. But in cases where your H4 is already approved, then especially if it was done recently, you probably will not get an EAD, a biometrics on that. Plus now with the biometrics having all those issues, it is becoming more and more difficult to actually go for the fingerprint itself, because it's becoming risky and all the problems going with it. So hopefully this will be alleviated, and now we know the elections is having a huge effect on everything, and we saw the RNC having this big show of people getting their citizenship, 5 people, so it's kind of a laughable matter, unfortunately, but we are seeing a lot of games being played, and the people who are really kind of affected by that are just the immigrants. At the end of the day, they are being the pawns who are being played with, and we hope that things will get better in the next few months.
Absolutely.
And there will be some good news coming, hopefully, if whether we change government or not. I think things are going to get a little bit better, and then unfortunately, depending on how COVID does, that will be the factor that will really kind of affect everything. But before that, it is not really going to. We're not going to see an improvement in the next few months until after the elections, I believe. So let's watch for that. At the same time, we might see certain things being given, just to get the votes. But bottom line, more bad things will probably come than good things. So be ready for that.
Yeah, no worries. We know when we have somebody as strong as you to advocate the rights of H4 visa holders, also, be it their visas or be it their EADs and work rights. I don't think we have anything to worry about, because you have yourself been a very strong advocate of that. You said that in the previous shows. We know that you have been one of the strongest voices, when it came to all those petitions. So thank you very much for doing that for everybody here. Thank you.
Thank you so much. I really appreciate your kind words. So,
listeners, let me just quickly remind listeners, if you have any questions, definitely call us right away on 510-657-1170, 510-657-1170. We have Shapir Ali on air with us till 11 a.m. Yes, Shah, you were saying something.
Yes. Anyway, thank you so much for giving the number. And today is August 26th, because sometimes people hear me, they don't know if it is a recorded show, and of course, once you get this situation, many people don't want to call. And also, a lot of people contact me later. They say they're a little bit fearful the way the climate going, that to call live to tell to ask their question. Just to let them know, don't give your name. and keep your questions general as much as possible. And if you want to do a private consultation, feel free to reach out to me, 510-742-5887. That is the number to our office, and the website pirali.com. And I think we have one caller, right?
We have Sharif on wait with us now.
Oh, Sharif is already there. Okay, ladies and gentlemen, so Sharif is part of our office. He works for the Washington, D.C. office. He's an attorney there, and he handles all the cases, mostly the cases of EB1, National Interest Waiver, and O1. Welcome, Sharif. Assalamu alaikum. How are you?
I'm doing well. How are you doing?
I'm doing well. I hope you can hear him well, Ira.
Yes, I can hear him fine, yes.
Yes, Sharif. Tell us a little bit, Sharif, what's going on and what's new right now. We know we are seeing ups and downs, but tell us a little bit about the ups first so that we can
Sure. Well, I think the first thing that I'd like to point out is, if you recall, I was on your show 2 weeks ago, and I had discussed with you the potential for USCIS furlough, and that they were that this was just a bluff, and that we've been saying this for the past 2 months, that the government does these kinds of things to discourage people from applying for immigration benefits, to make it look like a doomsday scenario. And a lot of people were falling into that trap, even though we were warning them that, look, this is a bluff, it's not going to happen. So we were right. I know you're a very humble guy. A lot of people admire that about you. You have an extremely, successful track record and so many, great successes. But you always remain humble. But I can't help myself. We we were right 100%, and the people, should recognize that when it comes to deciding how you're going to plan your most important decisions, you need to trust the professional advice. And you think that you're going to save, $100 of a consultation or whatever it is because you want to go on a forum, or you want to go and, cut corners or try to do something yourself. But at the end of the day, you should always consult with a experienced attorney that knows what you don't have to call us, but call somebody and make sure that you're getting sound advice with respect to your most sensitive and important matters that impact your life and your children's life and your family's life. So many people made huge mistakes in the past 2 months because of this furlough threat, which we both knew was baloney. And we called their bluff, and I never was persuaded that it was going to be a furlough. And the USCIS sent an email to the 13,000 employees informing them that, there's going to be no furlough and that it was rescinded. And this is despite no additional funding being sent to USCIS. USCIS operates on fees. They had announced about a month ago that there are going to be some fee increases in October, but despite not having any additional funding from Congress, as they were asking, they canceled the furlough. There's no furlough. It was fake news, if you will. And, nothing, the world's not burning down. Everything's fine, so people should relax. They should seek competent advice. They should be very deliberate and careful about their case and how they proceed and file it, and make sure that they collect all the evidence, that they present a great case, and that they don't rush things or become very anxious and make mistakes. So I just wanted to get that off my chest.
That's good. I hope we can hear Sharif properly, Ira.
Yes, I am able to hear him fine. There's no problem there.
Okay, perfect. Okay, so you're definitely right, Sharif. We are in the part, and thank you for the kind words first. But you are definitely right that they're playing the games, the same thing they played with the H-1B ban, and then suddenly they came up with all those exceptions. Playing that game with the base is is amazing. They're very good at it, and their base are thinking, okay, they're blocking immigration, but the truth is that most people probably will qualify under the exception, and they will be able to come back and to the U.S. if they are getting stamping. But that doesn't mean people should go out and on purpose just because they want to go on vacation, etc. If you have to go, then you go. If you don't have to go, or if you're stuck there, you come back. Don't try to really overplay, basically kind of try your luck too much, because there are issues, of course, when you go for stamping. So Sharif, tell us a little bit. Today we wanted to discuss a lot about, well, not a lot, but at least somehow about national interest waivers, because we keep hearing the word national interest, and let's talk a little bit about, because a lot of people think that they still have that set of mind that they need to have those publications, etc., that checklist. Give us a little bit more ideas. What will qualify someone for a national interest waiver?
I think that we obviously are very experienced with self-petition, particularly national interest waiver and EB1A, which is individuals with extraordinary ability. And I think that we've done so many successful EB1A petitions over the past several years that the national interest waiver is one that becomes almost open to, most professionals that are, among the, client base. So for individuals who are, already in the U.S. and are working in a, professional role, either in, maybe data science, software engineering, folks who are working definitely in a medical field, energy field, you certainly have a great path for a national interest waiver. Now, a national interest waiver, just so you understand, is an EB2 category self-petition, meaning those individuals who may, be born, for example, in India, where you have a country quota, you would get an approved I-140, but you would be waiting for your green card date to become current. Now, if individuals are born outside of India, for example, anyone that's from the Middle East, from Pakistan, Bangladesh, most other countries where folks are coming in from, a national interest waiver is a beautiful way to remain in the United States, to adjust status with a green card without having to have an employer sponsor you. So why do we call a national interest waiver a waiver? I think that's a good way to think about it. So we are waiving the requirement that normally exists when an individual is immigrating to the U.S. via employment-based immigration. So in a normal situation, we petition through an employer for one to remain or immigrate to the United States. A national interest waiver is a waiver of that requirement of having an employer-sponsored visa, wherein the employer must go to the Department of Labor and file for a permanent labor certification. So we are waiving the permanent labor certification requirement. That is why it's called the national interest waiver. That is where the word waiver comes from. Now, the first part, obviously, is national interest. So what is that all about, right? So just a side note, when we look at the immigration laws and immigration petitions, always look at the plain language of the statute, or in this case, the plain language of the category, right? And that is a great way to organize and think about your petition. So those of us who can kind of think outside the box and, create innovative, unique strategies for cases, as we often do, particularly with the self-petitioners, the national interest aspect depends on one major part of the case, which is that you work in an area of national importance or that your field of endeavor is an area of national importance and substantial merit. So I've done actually, just recent cases. I'm thinking about examples of success stories. We've had a really beautiful case that I loved, actually. It was a joy to work on it, of a really wonderful person who worked with autistic children. And, so her background was, basically in the, mental health arena and, particularly children's health. And she was coming up with really innovative learning techniques for, dealing with the autistic, children, because, this is obviously a huge problem right now and, growing. So it was really something where you could almost pull on the heartstrings of the, government officer in terms of, how we approach that kind of case. So where you are impacting vulnerable population, this is a wonderful case in terms of national interest. So that is something that I think, people need to understand, is that often with a national interest waiver, it's not only about what you've accomplished, but it's about the context in which it has been accomplished. So, if you've, and it could be, you could make a different case. I mean, it doesn't always have to be like a warm-hearted situation. It could be, for example, that you are in mineral mining or oil and gas, or, and then the national interest narrative is obviously going to be energy and economy. People who are in, different aspects of semiconductor, hardware, technological advances can definitely make a strong case for national interest waiver. Another recent success that we just had in the past couple weeks was, similarly, someone who was in the, hardware, kind of honeycomb, design. He was more of, this is more of like a civil engineering type of role. So, there's so much variety of cases that could fall under national interest. I actually think the changes that have taken place in the more recent years under Danisar case made it a lot more flexible in terms of the requirements for national interest waiver, and we're definitely seeing great results with national interest waiver cases. Because the EB1A is such a highly scrutinized category and we're being very successful there, it's almost like when we do a national interest waiver, it's like, we get a break from the heavy lifting. So, we are, again, really excited. And some folks are, well-positioned, can actually apply for both national interest waiver and EB1A. And oftentimes the way we do it is we work and prepare the case for an EB1A extraordinary ability under, first category. And then along the way, basically, because you're kind of, most of our clients, when we're dealing with an EB1A situation, it's almost like a roadmap where we start at one destination and we need to get to another destination. So it's not like, at the day that they sign up with us, they're, definitely qualifying and prepared to file their case. It is that we're going to work with them over an extended period of time in order to get to the point wherein they will qualify. And along that path, there will come a point where they, have sufficient evidence to file a national interest waiver. So obviously it's going to be additional work with, filing a brief that is different than an EB1A brief, but you can use the same evidence that you are gathering for the purpose of filing an EB1A to file a national interest waiver, because there's so much overlap in terms of, the national interest narrative. So, essentially, just to kind of give a full overview, when you're thinking about a national interest waiver, you're thinking about waiving the requirement for the labor certification and employer sponsor, and you need to have at least a master's degree. If you don't have a master's degree or its equivalent, there are what's called the E21 extraordinary ability criteria, which are not that hard to meet. I mean, you have, for example, a bachelor's degree, a certain amount of 10 years of work experience, salary. There's a lot of different criteria to meet, but it should be pretty straightforward. And then you have the DANASAR analysis, which is number one, that you work in an area of national importance, substantial merit, that you are well positioned to advance the area of importance that is identified. And lastly, it's a balance test in terms of, is the benefit of your role advancing the area of national importance that has been identified greater than the potential impact of not going through the labor certification process on U.S. citizen workers. So, ultimately it's one that is very manageable and can be, well accomplished with the right strategy and support.
Exactly. Sharif, I wanted to kind of put an emphasis on the first part you talk about, not the first part, the middle part, where you were saying that we work with you and people have to be patient. Sometimes people think preparing a national interest waiver or EB1 case is just a matter like preparing an H-1B where we can get it done within 1 week. I just ask them to really be patient, because sometimes people get frustrated because they think we're going slow, but we are not, because there's a lot of back and forth until we get it right. And sometimes we have to make sure that you meet the requirements according to our standard. We don't want to have a denial, just like you don't want to have a denial. Although sometimes even we put all our effort, there's still some denials, but at the end of the day, majority of our cases get done. So we urge you, if you want us to handle the case, give us a call, 510-742-5887, and I have Attorney Sharif with me today and Ira helping me to really put on a nice show. So any specific question on your side, Ira? Or we can go ahead and ask Sharif to continue and explain a little bit about all the issues.
No, definitely we should ask Sharif to continue, but before that I would like to invite all our listeners also to ask any questions. Listeners, in this conversation between Shah and Sharif, if you have any questions, you can definitely call us right away. Call us on 510-657-1170. That's 510-657-1170. That's the studio number. लेकिन अगर आप शाह पीर अली से या शरीफ से शो के बाद में डायरेक्टली बात करना चाहते हैं तो उनका नंबर है 510-742-5887. That's 510-742-5887, and the website to reach them is peerallylaw.com. That's peerallylaw.com. Their offices are in Newark, San Francisco, and Washington DC. So definitely get in touch with them, even for a virtual conversation or a phone conversation. Sharif, you could please go ahead.
Sure. So, again, I think those of you who are maybe not necessarily too excited about depending on the employer for their filing and want to go at it alone, particularly if you're on an OPT and you feel like you're in a strong position, or even if you're outside the U.S. I think more and more our friends outside the U.S. are, listening to, Shah Pir Ali Radio and contacting us to facilitate their, immigration. And it's really, a lot of people think right now is not a good time, but it actually is a really good time, especially if you're looking at a long-term strategy, because I think by the time that you have the approval for a national interest waiver, you're looking at 7 to 9 months. At the present time, there's no premium processing, so, it's just a regular processing case. And so if you look at the calendar, by the time you get the approval from Department of Homeland Security, go to National Visa Center, you're probably looking at, third or fourth quarter of 2021. And that might be, the ideal time in a post-COVID situation to, move and shift gears in terms of your trajectory of your career. So it's really could be excellent timing if that's what you're looking for. And one thing I've noticed with a lot of my clients is now that people are working remotely and have maybe a little bit more time to be flexible with their schedules, that, it's definitely an excellent time to collect the necessary evidence. Because collecting evidence and, going through that is a very detailed and, important task. So you want to make sure you get that right. And, I think timing is everything. So that's definitely something you want to look into. The other thing, if it's okay, I'd want to kind of touch on is what's called the O1 visa, which is a non-immigrant visa for individuals of extraordinary ability. Mm-hmm. Before I get into that, did you have anything else you want to talk about with respect to national interest waiver? Any questions or clarifications?
On my side, no. I think we pretty much got the point of the...
Shah, I can't hear you very clearly. Your voice is fading in and out.
I'm sorry. So I was just saying that I think on my side we pretty much got an idea. The main points of national interest waiver: number one, you don't need an employer. That's the main thing. Number two, national interest waiver can be very helpful on the fact, especially now, many companies are reluctant to file for the green card, and many people need that I-140 to move on with their H-1B beyond 6 years. And number three, you have a national interest waiver, it stays with you. You change company, it's not like you have to start over like you have to do with the perm labor certification, etc. So those are the three important points why you should consider a national interest waiver. The main point is that you're not dependent on an employer. They don't even have to know you're filing it. So anything else on the national interest waiver as an advantage, like in point-wise, Sharif, then we can move on, talk a little bit about the other visas.
Sure. No, I mean, the last point, and I think I've made this point in the past, is that if you are, if you already have an EB2 that is sponsored by an employer, it is really a great thing to get a national interest waiver, because that will allow you to kind of move around to another job without having to worry about a subsequent employer filing your national interest waiver. And the other scenario where we're seeing, people interested in national interest waiver is if you are getting age out of your H-1B, if you're looking at the 6th year and the company that you're working for has had layoffs, they're not going to be able to file your EB2. So you want to definitely file a national interest waiver in time so that you could continuously renew your H-1B if you are in a country quota scenario. So that is really, really important. You don't just assume that you have to give up on your, stay in the U.S. and that all is lost. There's actually really, great tool that is, very, very achievable, and we've had extremely high success on that one. So make sure you consult with us and reach out if you're in that scenario. So with that, I think I can kind of shift gears in terms of discussion of the O1 visa, because this is, again, something that I like to use for the entrepreneurs, whether you're outside the U.S. or within the United States. It is, first of all, a really great entry point in terms of moving toward eventual green card application. So an O1 visa, just to understand, is a non-immigrant visa. So it is not an immigrant visa. You're not going to get a green card based on an O1. It is, for temporary stay. You have to renew it for a period of every increment of up to 3 years. And then what we need to understand is that you can continuously extend the O1A as long as you continue to meet the requirements. However, you want to probably use the O1 as a vehicle toward getting an EB1A. Let me explain. There is a presumption under the USCIS Adjudicators Manual that permits the adjudicator to make an inference of qualification for an EB1A where one already has met the O1A. So it doesn't mean that you absolutely will be approved for an EB1A. You still have to go through and meet all the requirements, but it does help quite a lot. So you absolutely, if you are kind of in a situation where you don't think that you would qualify for an EB1A, but maybe, within a couple of years you could kind of work toward that, getting an O1A in the meantime is definitely a wonderful way to move yourself in that direction. An O1A is one where first of all, it's a company-sponsored visa, so this is not a self-petition. You actually need an employer, a business or educational institution to sponsor your visa. Now, this can be a closely held company. So, for example, we've done O1A petitions where the applicant is actually the first employee of the company. We've also done it where it's, the second employee and so on and so forth. So if, for example, we're looking at a startup scenario, that is, one where an O1A can definitely work. And the eligibility criteria for an O1A requires that, again, you have the employer sponsor and you meet a minimum of 3 of 10 criteria that are laid out in the statute. Now, those criteria are similar to the EB1A, and basically you need to meet at least 3 of those criteria. So, but one thing I want to point out is that the scrutiny that is applied to the O1A is far less than the scrutiny applied to an EB1A. So, for example, if one has, maybe a salary of between $130,000 to $160,000, they will likely qualify under that criteria in an O1A scenario. But in an EB1A scenario, they're definitely far more, looking for probably, 200,000 range at least, depending on the area of endeavor. But here, I think there's much more flexibility. Likewise, the critical role, so employment in a critical or essential capacity, is a lesser criteria than the EB1A perform in a critical or leading role. So there's a difference in the language. Employment in a critical or essential capacity versus performance in a critical or leading role. So that would be the difference there with respect to the plain language of the statute, with the O1A criteria being the easier. So it's easier to show critical essential capacity versus critical or leading role. There's a minor distinction, but it makes a big difference in terms of adjudication. Participation on a panel or individually as a judge of the work of others in the same or similar field means basically that you're doing maybe peer review of journal work, or, for example, you can find a scenario where you're doing what I call professional review. So it could be that you are invited. Now, the main thing that you need to understand about this criteria is that you are doing it outside of the normal course of employment. The normal course of employment means that you are not reviewing and judging work as part of your job. So, like, a lot of people say, oh, well, I supervise employees or I give, feedback. That does not count. It needs to be something that is outside the normal course of employment. Now, it could be, for example, that, somebody contacts you from India or China or Europe and that you're conducting a review for a foreign organization or a company. But the main thing that you need to understand here is that it is outside of the normal course of employment. One other really important one I would point out is when we think about original contribution of major significance to the field, I could say it 1,000 times. This does not depend on the number of citations you have. I know that this is contrary to everything that is on the internet, it's contrary to every forum, it is contrary to everything. But look, I know I'm 100% right about this. I mean, I've proven it. It does not depend on citations. It does not depend on citations. It does not depend on citations. It depends on whether you've made, for example, a business-related contribution. So, for example, as an attorney, I'm not necessarily publishing scholarly work. There are different kinds of contributions that we are making. Likewise, a person who's a data scientist should not necessarily have to go out and start publishing articles. It may be helpful to do so, but in terms of their major, most important contribution that they've made in their career, it will not likely be a scholarly-related contribution. It would more likely be a business-related contribution. And for a business-related contribution, you need to look at whether you have either significant impact on subsequent work in your field, so whether other people have adopted your practice or protocol, or whether you have made, for example, something that has received attention, widespread discussion. So widespread discussion is traditionally understood to be citation, but for example, if one is involved in the development of a product, and that product is then featured in Wired magazine, or let's say somebody launches a database, and that database is for the motor vehicle department, and there's a newspaper article that the motor vehicle department has launched a new database, that then would be a significant business-related contribution. So you need to open your mind in terms of how these approaches take place. Just trying to follow a template is not going to work for most of our clients out there, potential clients. It's really, really important to reach out and consult with somebody that has great experience in this area and can assist you in this regard.
So Sharif, just to let people know, this is Attorney Sharif from the Shopify Law Group. He's in charge of the Washington, D.C. office, and he's talking about the O1 visa. And just to let people know, this is a very good chance to really kind of get an alternative to an H-1B. For one, the O1 has no limitation. It can go on for a long time. You don't have to, there's no limitation like 7 years, 6 years like the H-1B. And also the limitation of the salary. So if you qualify for it, it's a good chance to take it. So Sharif, tell us a little bit more.
Yeah, I think so just in terms of limitations, right, I don't want to oversell it. One limitation of the O1 is that the spouse would not be eligible for a employment authorization document based on having an O2 or being a dependent. So, for example, it may be if, for example, one is on a H4, it may be a good idea to move to an O1 as the first step to applying for EB1A, or for just starting her own business. But if one is on an existing H1B with an approved I-140 and they're able to renew that, and their spouse is working on an H4 EAD, then it may not be best for the primary individual to apply for an O1A. It would probably be better for the individual that's the H4 dependent to apply for the O1A. So if you're looking to start, let's say, a family kind of, a business or maybe a consulting company, I know a lot of my clients have done that, where they are, for example, one of the, parties is, looking to start a business, she can do that using, the O1A process, through some other measurements in terms of how the organization is structured. I don't want to get into those details. I don't think we have enough time, but you definitely need to reach out and consult with somebody in order to make sure that we can help you in that regard as well.
Sharif, see, when you started talking about O1, the first thing that you mentioned was O1 is for people with extraordinary abilities or some extremely special talent. So if somebody wants to apply for an O1, what kind of special abilities or talent would they have to show? And then when you say that if they want to run a business, a family business, or in consultancy, how is that some kind of extra talent, special talent or extraordinary ability?
Yeah. No, thank you for asking that. I think that, it's really based on everything you've done up until the point in time of the application. So really, when we think about the business, what we're thinking about is a startup business, like maybe a technology startup, or, something that involves, for example, some high-skilled, even business management skill can definitely qualify if you are in a very narrow field of endeavor. But what we're looking at in terms of extraordinary ability is extraordinary ability within a very specific field. And the way that you demonstrate extraordinary ability within the context of the O1A is by meeting 3 of the 10 requirements that exist in the statute. That is, for example, I went over a few of them, but, receipt of lesser-known awards for, something that you've done, membership in associations in the field for which, you're seeking classification. One popular one is senior membership in IEEE, publishing a scholarly article or professional, related article, original contributions. They could be business contributions. They could be technology contributions, original contribution of major significance to your field, authorship of scholarly articles, commanding a high salary, participation as a reviewer or judge of the work of others, and having been employed in a critical or essential capacity. So those would be the scenarios that would make a lot of sense for somebody who is seeking an O&A. Okay. So it is called extraordinary ability, but, with the right approach, we can definitely, shine off people's, qualification and make sure that they qualify under the necessary criteria.
Right. So if there's an O1A, I'm sure there's an O1B also. So, but today we are out of time, but I think in the next show we should probably talk a little bit about O1B also. Exactly. We are about 2 minutes away from the end of the show. Shah, would you like to add something in the end?
Yes. So basically what Sharif is saying, you asked that question on the O1.
I can't hear you.
Yeah, what I was saying is that what Sharif was answering, I hope you can hear me now, the situation is like, until we really take the case and put it together, many times people don't realize they are extraordinary. That's the part which is the most interesting. Many people who are actually qualified, they are very humble, so they don't really see things that we can see, and this is what you basically are hiring us for, to see that from that different eye. And Sharif is very good at this. So Sharif, I think we have 1 more minute to go. Anything to close? I just wanted to let everybody know, if they need help, call us 510-742-5887. And anything we told you today is our opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any question. Few last words, Sharif. I think we have 30 seconds.
Well, I was just going to make a joke. If they're worried that they are not extraordinary, it's okay, because we are extraordinary. So
wow, that's very savvy. That's very nice. Listeners, if you don't have talent, don't worry. They have talent. They'll make sure that they show that you have talent. Wow. Thank you, gentlemen.
Thank you, Ira. So thank you, ladies and gentlemen. We'll be back next week.
Absolutely. Thank you, Shah. Thank you, Sharif, for being on air with us. Absolute pleasure to have this show once again. Listeners, remember to get in touch with them. Do call them up on their office number 510-742-5887. That's 510-742-5887. And the website is peerallylaw.com. That's PEERALLYLAW.com. And their office in Bay Area is in Newark and also in San Francisco. And Sharif the East Coast, and their office is in Washington, D.C. So definitely get in touch with them. They will be back with us next week, same time, same place, Wednesday morning, 10 a.m. to 11 a.m. Meanwhile, you have a great time and stay home, stay safe, and stay tuned to Radio Zindagi. Jai Jai.